Number 8. He is 14, a quiet freshman from Niles, Michigan, spending a weekend at his grandparents' house after a cascade of losses that made the world feel small and airless. His name is Dakota Wolfgang Eliasson. Friends had watched him sink into a deep sadness. A recent breakup, a friend's suicide, nights spent awake and alone. Court records and long-form reporting describe a boy who fixated on death in his journal and in late-night thoughts, holding his step-grandfather's revolver and weighing an end to his own life. Instead, just after midnight, he walked into the living room where his step-grandfather, Jesse Miles, slept on the couch. Detectives later pieced together a portrait of a teenager in crisis, more than a calculating planner. The Michigan Court of Appeals summarized testimony about depression, intrusive thoughts, and an adolescent's narrowing judgment under stress. Family members told the court that Jesse Miles had been kind, the sort of steady presence a drifting teenager might cling to. The tragedy was that the very person offering stability became the focus of an impulsive act. From the first hours, the case carried a heavy psychological undertow. Grief, numbness, and the adolescent belief that one irreversible act could quiet the noise in his head. Police arrived quickly to a house near Buchanan. Prosecutors charged Dakota as an adult with first-degree premeditated murder and felony firearm. A Berrien County jury convicted him in late summer of 2010. That autumn, the trial judge imposed the only sentence then allowed for a juvenile convicted of first-degree murder in Michigan adult court: life in prison without the possibility of parole, to run consecutive to a separate 2-year term for the firearm count. The ruling left a 14-year-old facing a punishment usually reserved for adults, and the case moved into years of appeals. The legal ground shifted beneath the file after the United States Supreme Court barred mandatory life without parole sentences for juveniles. Michigan sent dozens of old cases back for new hearings. Appellate judges affirmed Dakota's convictions, but ordered resentencing consistent with the new constitutional rule. In the spring and early summer of 2015, witnesses returned to court. Relatives describing the wound that would not close, counselors speaking to remorse and treatment, and the judge weighing adolescent development against the gravity of the crime. At resentencing, Judge Scott Schofield acknowledged the brutality and the bewilderment, how a beloved step-grandfather who had been nothing but kind could be killed by a boy he trusted, and also the science on youth and change. He rejected a renewed life without parole term and imposed a finite adult sentence. News reports and defense summaries record the outcome. For the murder count, a minimum of 35 years and a maximum of 60 years, with credit for time served and the earlier 2-year firearm term already accounted for. In open court, Dakota apologized to the family, telling them he could not undo what he had done and describing efforts at therapy and education while incarcerated. The psychological story never delivered a clean motive. Defense filings emphasized depression, suicidal ideation, and the impulsivity of adolescence. Prosecutors pointed to choices made in the quiet of the night and the finality of the result. Even the judge called the act bewildering, noting both the harm to survivors and the possibility distant and contingent of rehabilitation over decades. The conflicting portraits remain: an unstable teen overwhelmed by despair, and a convicted murderer held to adult accountability because the law could not ignore the life taken. Today, Michigan's offender tracking system lists Dakota Wolfgang Eliasson as incarcerated on a sentence of 35 years to 60 years for first-degree murder arising from the early March of 2010 killing of Jesse Miles. His record also reflects the separate 2-year firearm sentence imposed at the original hearing. He is currently housed within the state prison system, with parole eligibility decades away, under the term of years set at resentencing.